And we have two items on the agenda this evening. One is post-public hearing review of the Cirque Meadow subdivision DRI 741. Our task there is to review the applicant's offers, possible conditions, and draft benefits and detriments, and make a recommendation to the full commission as to whether to approve of conditions or deny the application. The other item is a review, I believe a compliance review / maybe modification review of the Stone Bank building development. And I am recused from that. And once we finish Cirque Meadow, I will hand the gavel over to Fred Hancock, who's been appointed by the chair to act as hearing officer on Stone Bank. So first, let's start with Cirque Meadow. Rich, can you tell us what materials have come in since the close of the public hearing?
Sure thing. We received a updated set of offers from the applicant. There has been and that most notably in that updated set of offers is a retraction of the trail easement that was on the original set of offers previously presented to the commission. There have been, while the record was open, there were some neighbor letters that were that objected to the trail easement along Old Meshacket, and one land bank letter that was in favor of it. That is pretty much the crux of it. I'm going to
Okay, and we also received draft covenants.
That's correct.
Okay.
Why
Why don't we get the applicant offers up? Let's go through them.
you got it.
June 1.
I make 8, right?
You know you make 7 unless somebody else is.
Oh, okay.
Yeah.
I
Alex,
can't.
I need to screen share, my friend.
Yeah, Alex, you need to change that to him.
Actually, I might make 9.
Is Jeff recused on this?
Yes,
Okay, so that's one down. Wait a minute.
there's only 7 unless I
1,
can't.
2, 3, 4, 5, 6, 7. Joan, you're 7.
I guess I can't count.
Everyone see this okay?
Count.
Yep.
All right. These are the amended offers from the applicant. The first 59% of the property will be reserved for open space in perpetuity. The open space will not only include the central meadow, open space B on the plan, but will feature buffers along Meeting House Way, open space A, and Division Road, as well as additional open space buffers along the abutting Island Grove subdivision, fragmented space that is not included in the 55% number. Please see attached Cirque draft Meadow declaration of restrictive covenants and road maintenance provisions.
Are
The
we,
meadow- I'm sorry.
I just want to know, what's your plan, Doug? Are we commenting it as we go along? Because I didn't,
Well, I think what we ought to do is look at these in groups, and I think we can look at the first 2 because they specifically address the open space. So
cool.
the second one is open space B, which is the meadow, will only be mowed once a year, and the vegetative buffer between the meadow and Division Road will be maintained as it is, and the meadow will not encroach on it. Are there any commissioner comments regarding
Yes.
these 2?
Number 2, will it not be mowed more than one time per year? That's great, but it depends when. You could mow it once at the wrong time and be damaging any whatever threatened species that might be there. So I think we need a little more detail than that. Somebody needs to have a species list and if anything is on the restricted or endangered list, we should know when it will be cut.
Well,
So
that's
my
the
solution-
problem, Melinda. That should have been done during the public hearing. Doug Hahn, is there, as for clarification, is there an inventory of species in the meadow?
The only part of this property that is in the natural heritage jurisdiction for priority habitat is way down the south corner by the intersection of Division Road and Meeting House Road. Basically, the entire meadow is outside of that area.
Okay, and so there is no inventory with regard to what, if any,
That
endangered,
fact needs to be in the record.
pardon me?
That fact needs to be in the record.
Well, the record's closed, but
Too
my
late for
solution,
that, Linda. We
my
didn't.
solution
they
would
didn't
be,
know.
Actually, okay, we can argue about this some other time. But
Right.
if we have erred in requiring them to put things in the record, shame on us.
Okay, well, it's shame on us. That's what the record is. Do you have a
easy
suggestion as?
solution. Yeah,
Go
we
ahead.
could simply, as a condition, require them to come back with a mowing plan. Which, and that would go to LUPC, and it's, doesn't go to the heart of the proposal, but it would give us a chance, we give them a chance to see whether there is flora or fauna which needs anything, and to come up with a normal mowing schedule for meadows.
Thank you. And for future record, I would ask staff and members of the commission
Oscar,
to keep that in mind in advance. This is one of the important things that we do.
Okay, let's use our yellow hands so that we can have some regularity in this, Fred.
Yes, I recall during the public testimony, there was testimony about it being mowed, that it had in the past been mowed once a year, and there was a time indicated about what time of year that took place. And I believe they also said that their plan was to continue that.
I believe Dickie Brown used to do it. Isn't that what the testimony was, Doug Hahn?
Yes, but then the current owner has also picked up and done it, in the years since he's owned it.
Yeah.
I don't remember if we said anything about the time of year. Rob, I don't remember. Did we say that? I don't think so.
We didn't say
We'll find
one
it.
time,
We'll
we didn't
find
say
out.
what time of year. We did initially propose not more than 3 times per year, but then upon hearing this feedback and hearing from Burke that it was only mowed once, I just don't know what time of year that is done.
Okay, let's go
So
back.
we amended it down to 1 year, 1 time per year.
Okay, so
thank you for your help.
the way to address this would be as Joan suggested it, and I've made a note that we may want to add a proposed a draft condition for that. That doesn't mean we have to not accept number 2. We could simply further condition it. Anything more on numbers 1 and 2?
Yes.
Go ahead.
This may be obvious, but the references in number 1 and number 2 should specifically refer to the plan. And I don't think I would, in other words, what I would like is if I don't really want to find that the open space areas have been adjusted. Well, at least not without our knowing about it. So I just think that if I like what's there, I just think it should be as set out in the plan, blah, 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 which means unless that's a clarification that Doug is happy to make.
Yeah, that would be the plan dated June 1. Is that correct, Doug Hahn?
Yeah, the most recent one I sent, I think, let me see here. What is it? Oh, geez. Yes, June 1, correct.
Okay, so that's easily rectified in the 3rd line there.
Yeah.
Joan, I just want to announce Ben Robinson is here. He is the 8th member, so we can't go any farther. Go ahead, Joan, sorry.
No, that's fine. So that was the only thing I wanted to say. And I guess it's quite clear that number 2 also relates to, I'm sorry about the background noise, also relates to my husband is. Sorry, also number 2 relates to the very same plan. That's it.
Yes, I put those in the covenants. The reference to the plan is in the covenants. I can put them in the actual offers.
Yeah, the covenants are currently only in draft form, so I think,
That's correct.
yeah, maybe it should be in the offers.
Okay.
Thanks.
No harm in repeating.
Okay, let's go down to number 3. No subdivision, no further subdivision that creates additional building lots. Whoa, why are you going past number 3?
I apologize.
Leave it there. I take it that there'll be no further subdivision, period. Isn't that the proposal?
Yes, so this is just a kind of a standard thing we've kind of usually use in case a property line between 2 lots needs to be adjusted for some reason.
Yeah, well,
So
that's not part of the subdivision, though. That would be a property line adjustment.
that's not really a subdivision, it's a division or a property line adjustment, correct?
Okay. Any comments on number? Go ahead, John.
Yeah, so I Doug, this isn't really a question for you. They'll be protected in perpetuity. Are we able to just say that, or does that need some sort of a, I don't know.
Well, it's going to be in the covenants, which are going to be recorded, although covenants can have to be renewed every 30 years. However, if it is an offer that they've made to us and we accept it, and that gets incorporated in our decision and it's recorded, then it doesn't matter if they don't renew their covenant because our decision says no further subdivision.
That's good by me.
So it's belt and suspenders. Anything more on number 3? Number 4, there are covenants and restrictions on road maintenance, architectural review, ownership of open space, and management of open space. I forget what it says about ownership of open space. Can you, Rob, can you tell us?
Yes, sorry, I was muted. I believe it is going to stay with, well, it's going to be conveyed into an association, the Cirque Meadow Association, which will hold the fee in the open space.
And be responsible for it.
Exactly. And everybody's, assuming they build out these lots, everybody's going to contribute to fund the Cirque Meadow Association, which is going to be in charge of not only the open space, but the road that services everything but Lot 5. Lot 5 is going to be its own little entity with respect to the road that goes to it.
Go ahead, Joan, and then Fred.
Yeah, so I just wanted to say that I think we often, correct me if I'm wrong, make these homeowner agreements subject to LUPC approval.
True.
So, I mean, I think we just simply need to make that a condition.
Yes.
So the final covenants and restrictions will be submitted to LUPC for approval.
Review and, yeah, right, okay.
For review and approval prior to, Jesus, really should be before the first building permit.
Yeah.
Fred?
My question is, does the homeowners association come into being when this subdivision is recorded or when the first building permit is issued?
I believe when it's recorded.
At which point I would imagine the homeowners association will consist of the husband and wife who own, well, actually it's an LLC that owns the whole thing. Okay.
That's what it will consist of. And again, like they're only planning on building on one of the lots now, Lot 5.
Right. No, I was just wanted to make sure we understood who is in charge of the open space.
Yes.
Brian?
Yeah, we have a few lawyers here, so I'm just curious. So if they wanted to come back to us to pave a driveway because a family member has to use a wheelchair. So they'd come back to us for a modification, but then what do they have to do to fix the covenants to reflect that?
That's their problem, to put it.
I'm just curious.
Yeah, they would have to, well, they could, I think, probably amend the restrictive covenants. But they would need probably, unless the covenants have some other provision, a unanimous agreement among all owners of the
And
subdivision.
they're all family members. Okay.
Yeah.
Okay, thank you.
That they can, if we let them pave something in the future through a modification, they can amend the restricted covenants, as long as the covenants have provision for amendment. And I'm sure Rob put that in. Go ahead, John.
Yeah, no, I'm on the same one that Brian was on, and Doug, don't laugh at me when you hear me say this, because I hardly know what I'm talking about, but when it says no paving, I'm assuming that you mean, or Rob, or other impermeable substance, because I think in my stupidity, I think there's probably things that are impermeable that are not paving, but I could be wrong about that.
Yeah, concrete.
Yeah, right. So I'm assuming you mean no paving or other impermeable surface. That's clarification. Am I right?
Impervious, right?
Yes.
Thank you.
Other impervious surface. Got it. Okay. Number 6, straightforward. They'll comply with fire department regulations regarding access.
I hate to say it, but I
Comments?
comment. My comment would be at the end of number 6, it should say as determined by the fire department. Again, I'm just seeking clarification so we don't have to have a condition, but I'm assuming that that's what you meant.
Yes.
In other words,
Yes.
Yeah, okay, great.
Okay, number 7. You're not going to tie the property. You're going to tie all proposed lots
Correct.
in the application to town sewer and will meet MVC water quality management. I had a question about that, and that is, you did a nitrogen calculation that showed you met the water policy, water quality policy, if you used septic and you had, I believe, 4,000 square foot maximum fertilized lawn and gardens. Is part of your offer to limit fertilized lawn and gardens for each lot to 4,000 square feet?
Well, that's what your open space policy, I mean, not your open space, your water quality policy
Okay.
limits you to. I mean, and if you remember discussions in the past about this, is that that's a high that 4,000 square feet of fertilized or managed lawn and shrubs, whatever it's called, is a high nitrogen generating number. But
Yeah,
it not only applies to that, it applies to anything else you do on the lot, like just brush cut it. There's no differentiation between it. But it does say in your policy 4,000 square feet.
okay. Thank you. You have a better memory of the policy than I do. Any other questions by commissioners about number 7? Okay. Number 8. When I think of a phase subdivision, I think this is going to be a phase subdivision. They're going to do, the owners are going to do, the mom and dad are going to do lot 5, and then the others will not be constructed until necessary. I guess it would be phased in that one will be done and the other 4 could all be done at once, which I don't think is your intent. And what constitutes necessary when one child decides they want one? Or, I mean, I don't think you want all 4 of them building houses together, and I know that it's extremely unlikely, but do you have some suggestion as to how to do that?
I think that applies, Rob, correct me if I'm wrong, I think that applies to the construction of a 30-foot way. Because that does not need to be constructed until someone applies for a building permit or is getting ready to apply for a building permit in lots 1 through 4. So we're hoping not to have to construct that for who knows how long. We got to work the details out with the planning board in Edgertown.
Yeah, you don't
Right,
want,
that's what that applies to. And I
Yeah,
apologize for my,
it's a major expense.
comment.
So, understood.
So that means that it would just simply take out the other lots and it would just say the 30-foot wide access road will not be constructed until necessary. Is that what you're saying, Doug? Yeah.
Yeah, I believe, unless there's something else there, Rob, I think that's what we're saying.
yeah,
Yep.
that was the intent.
Okay, so that is helpful.
So it's the 30, okay, the 30-foot wide access road, but not until necessary. Okay. Any other comments from about number 8?
Should that say, just to be clear, the 30-foot wide access road to the other lots?
Yeah.
Will not be
Yes.
constructed until until,
Yes, that's what I meant to say.
Just
Number 9.
before we get too far down the road, just procedural question. Rob, are you planning on, based on our clarification of your intent, issuing revised offers, or are we going to come up with conditions? Just asking. It might help you take notes if you know the answer to that question.
I think that
Oh,
they
I'm
should
taking
be
notes.
submitting revised offers to the extent that these are clarifications, if they are willing to incorporate them in offers. As to if they want to incorporate the mowing plan, that would be better.
I mean, I don't care. I just want to know what to expect when we get to the full commission.
Yeah, we would prefer that they be offers. And it
I can
sounds-
revise them. I'm happy to revise them.
Sounds to me like everything so far is something you're comfortable with.
Yes,
Number
And-
10, everything is electric except propane gas. I assume when you say cooking, you mean stovetop cooking.
correct.
Below that, you say the ovens will be electric. Okay,
Yes, that's correct. Those are dual fire ranges.
okay. And if the House of Representatives has its way, your right to a propane gas stove will be federally protected someday.
Well,
I know that gives us all a great deal of relief.
they're trying to
Brian,
solve the world's problems. I know.
Yeah, I know. Brian and then Joan and then Adam.
No,
Yeah, I'm
mine-
just not sure I understand this. So the oven has to be electric and the cooktop has to be, or can be gas?
Correct.
Nobody does like gas ovens anyway, because they're not nearly, well, I wouldn't say nobody, but nobody who really cares about baking does. Because they're just not, they're not as efficient or as even. Work.
Yeah, they're not as even, apparently. Not that I cook that well.
Well, I've learned that from my spouse. So it's not going to be a burden on the applicant.
Yes.
You have something?
Me?
Yeah, yeah.
I just wanted to say, just for the record, that we will accept revised offers, but they're just to include clarifications. They can't.
Yeah, well, we've done tonight.
I just want to just put that in the record.
That's clear. Appliances, well, we just did it. Appliances are all electric and will comply with our energy policy. Anything about these?
Thank you, Bill. Thanks so much.
Okay, number 12, exterior lighting, downlit, dark sky, and do we have to add the 3000 Kelvin to this, Fred?
yes,
Okay. So that's another thing we'd ask you to clarify, that the illumination will be no more than 3000 Kelvin. Okay, Fred, you had a suggestion with regard to 13 about complying with the affordable housing contribution.
yes, I did. Actually, two things. The first one is, I think it should say the contribution should be made as required by the MVC housing policy. We've dropped affordable from our policy at the time of the sale. so should this happen, the first sale happen some 20 years in the future, it would be, the amount would be governed by the policy in effect at that time.
By the then applicable MVC housing policy.
In effect at the time of the sale. Also, have we defined Ross family here? Are we talking about the owners and their children, or does it go beyond that?
So my question is, does the, Fred, did we deal with that question as to whose family, or did we just sort of finesse it when we made the exception?
We did not define it in my recollection.
Yeah, I think that's correct.
Rob,
Because
do you have a clarification as to what the Ross family is? I don't think we're talking about 12th cousins here.
No, we're not. I can talk to, I believe it's Burke's kids.
That's what I assume. Yeah.
Yes, so I will clarify that and put it in the offer
Okay,
and define it.
Una
thank you.
and Bert, there's a couple others.
He does have 4 kids.
Yeah,
Um,
That'll work.
They're not
I
gonna
don't think
sell
14 is a statement of your position, but if you're not, it's not really an offer. It's we're withdrawing one because we know that the abutters objected, and that's fine. But it's no longer an offer. It's just, it is what it is. You're
that
not
is what it is. It
The
was
entire
included.
14 can be eliminated.
right. And that was it for their offers. And they're going to clarify the things we've discussed, and specifically, as Linda pointed out, the need for, and Joan identified it, the need for a mowing plan that probably should identify any endangered species that is in the meadow that might be affected. But you're going to come back to LUPC for review of that. As to these offers, I think we can do these independently of the possible conditions, because the possible conditions are pretty scant. Are there any further comments about the offers? Does any commission wish to make a motion with regard to recommending approval or disapproval of these?
I would move that we accept the offers as they might be corrected, as we've indicated.
Clarified, yes.
Yes.
I'd second that.
Assuming that if this application is approved, it would be approved with those offers. That's what you're suggesting, I think.
Yes.
Okay, and there's a second to that. Any further discussion? Okay, all in favor of making that recommendation to the full commission, kindly raise your hand where I can see it and count it. 1, 2, 3, 4, 5, 6. And I don't see Ben he's not showing.
Brian, your hand raised? Yeah.
Oh, 7.
Doug, I believe I make 9 on my count.
I thought
Jeff
Ben-
is recused.
Jeff is
recused.
recused. Okay.
So
That makes that clear.
are you voting in favor or opposed or abstaining?
I'll abstain because I wasn't paying attention as close as I should have.
Okay, so the vote is 7-0 and 1, 7 in favor of the recommendation and 1 abstention. Okay, let's look at the possible conditions. There are only a handful, and they are the standard conditions. However, I'm not sure that as the drafted, the first 2 really apply. We always have a final landscape plan, a final exterior lighting plan, but this is for a subdivision, not for.
Right.
I you do a landscape plan for 5 separate lots.
I think we would normally not have them for this, for
Yeah,
1 and 2.
Or
Yeah.
3,
pardon me, John?
or 3 for that matter.
Yeah,
That's true.
I mean, we're not voting on buildings, we're voting on the subdivision and
Sure.
perhaps the building
Yeah.
envelopes, but
Okay.
Mr.
Num-
Chairman, the mowing plan might take place of the landscape plan.
Well, that depends. I think the applicants indicated that they are going to revise or clarify their offer with regard to the meadow to include that. If they don't, we could add it as a condition.
I-
We should make a note that if.
I don't-
Go ahead, John.
I don't know whether it's overreaching, but we kind of lose jurisdiction of these houses. Once we approve the subdivision, it's out of our hands. The question is, would we want to impose as a condition, not approval of a final landscaping plan, but that only A and B and C, and that may well be in the covenants. But I guess the question is that the kind of thing that we would want to assure ourselves of for the actual development of the lots?
If you're familiar with the family, you'd know that they're gonna do the right thing. And one of
That's
them
not
could've been
really
taken
how
out.
we do it. We, you know,
Well, never mind. Go with.
the problem, Trip, is not with the family, but with successor.
They're never gonna sell, believe me.
Well,
This is gonna be it till they croak, and then in 50 years, they wanna come back anyhow. It's all right. I don't
well, it's good that
drag
Yeah,
them around.
kind of people. It is. Linda?
Yeah, I want to express regret at the loss of the walking trail. I did state, and I still feel this way, that when a large subdivision like this comes in, that they shouldn't impose things like trails that are primarily an imposition on the next door neighbor and not on themselves. But I regret very much the loss of that access, and I'm sorry that the applicant didn't find a way to move that trail in such a way that it wasn't a flagrant imposition on the neighbors.
Well, any commissioner could propose a condition that we could discuss and determine whether or not we want to recommend it to the full commission with regard to any aspect of this, including the walking trail.
That's true, but at this point in the planning process, it would be awkward. It should have been figured in the configuration of everything early on. And again, I would hope that in the future, either the pre-public hearing LUPC or the staff would work with applicants to resolve this obvious problem. You know, no, don't put a walking trail on the edge of somebody else's property, but try to build it into your design.
Brian?
Well, just to address Linda's comments, I've dealt with this in the past, Linda, where there was a walking trail, you know, between a large property and a subdivision. And that walking trail ended up being, for the most part, where the people who lived in the subdivision threw their, you know, grass and leaves and kind of use it as a dumping ground. So I'm not sure if we allowed or if a walking trail happened here, it would actually be a walking trail. My experience is it turns out to be a place where the neighbors kind of dump the stuff they want to get out of their yard.
Okay,
Do I gather that no one has any interest in imposing restrictions on the, shall we say, landscaping of the houses to be developed?
They don't.
I think that it's, there, I would say no, just because the enforcement becomes something that we're not really prepared to do, I don't think.
Yeah, I wanted to ask, because I do think it's important and I do think it's relevant, but I understand where you're coming from.
And we have in the covenants, the number 2 is covered in the covenants. I mean, in the offers.
Although
Yeah,
we
you're
don't
not
have to
so much
approve-
worried about that one.
we don't have to approve a landscape plan. The 3 bullet points might be worthy of including as conditions for the development of each lot. I don't think that it would be overly heavy-handed.
Why don't we, Doug, just to move on, why don't we put them in as part of the proposed conditions, those 3 little bullet
Yes.
points? Or require that they be incorporated into the covenants at the election of the applicant, and then see if the commissioners are interested in it, but just, put it in.
It would be consistent with past practice. We don't wave our hands and say, I don't care if you dump nitrogen next to your neighbor. We always require this kind of thing. So I think
Not
we
in the
include it in-
subdivision,
What?
Let's
not in a
just put it in.
subdivision.
Yeah, I know, let's
Well,
put it
I
in,
disagree with you. I
let's
think
put it in and we
should.
can argue about it later. When we have
Yes, I
17
agree.
people
I think what we
arguing.
want to focus on with number 1 is not a final landscape plan, but as a
Correct.
possible condition, the 3 bullets that are in number 1.
Correct.
Fred, you have your hand up still?
Muted.
Yeah, you're muted.
I'm
Hey.
sorry, we should get rid of number 2 though, because it is in the offers.
Okay. And we'll be accepting it anyway. Okay. I don't think we need 3. Number 4.
Right.
Doesn't hurt and is consistent with their offers anyway. And number 5, we always have. Any other possible conditions that commissioners wish to raise?
I would ask, the no curb cuts or buffer zone cutting. I get it, that applies to Meeting House Way. Indeed, that's required with your agreement with Vicky, but what is the, I'm sorry, I just cannot remember with respect to Division Road.
Division Road has a vegetated buffer. It's all part of open space A, isn't it, Doug?
Open space, open space B is the one along Division for the most
Okay,
part.
excuse me. Yeah.
Yep.
Okay,
that's
so
a
that means
no
you
cut.
couldn't, does that mean that you wouldn't be able to, let's say, whoops, that just disappeared.
Right.
Does that mean you wouldn't be able to, what did it say? Not curb cuts, but the other thing, cutting?
It
Could
said
you,
open.
would you mind going back, Rich?
You got
Number
No, it's
2.
but it's the plan to show you where the curb cuts are.
Yeah, but I'm not worried about the curb cuts.
Isn't that what we were just talking about?
No, buffer zone cutting. So I am assuming there's no cutting in that, what do you call it? Open space B.
The vegetated buffer immediately adjacent to Division Road shall not be encroached on by the meadow that's in offer number 2.
Does that mean there's no cut? Does that mean there's no cutting?
I think
That's what it means, fine.
that's what it means, doesn't it, Doug?
Okay,
Yes,
But
okay.
Gotta
we're
clarify that.
talking about Meeting House Way, not Division Way.
No, I'm talking, I'm happy with 3. I was just curious as to why it was silent as to Division Way. But I understand, Doug, that you're saying that essentially that is what your offer 2 says.
yeah, it's already covered by the
Okay,
conditions on the 2 open space lots.
got
Right.
it, got it.
And as to our proposed, our proposed number 4 there, I think we should identify that as open space A. Okay, so let's add,
Yes, yes,
understood.
yes.
okay, so keeping in mind that number 2 is out. Number 4 will identify the area as open space A, and number 1 will only be the 3 bullet points. Those appear to be the only possible conditions that have come up for discussion. Mr. Vina,
Yes, I was wondering if you might want to allow for for vegetation to be cut for a trail if at some time in the future, the applicant wants to provide a trail, perhaps along Division Road or whatever. But not to have a prescription against that from occurring.
trail where besides
In in the no-cut buffer area.
along
I would
Division
say they
Road?
should come back.
I
mean,
agree with
any
Joan
proposed
entirely.
Location
Yep.
would
They can
They
come
should
back.
come back.
That makes more sense. Okay. Anything further? As I clarified, number 1 will just be the 3 bullets. Number 2 is gone. Number 3 is gone. Number 4 will reference open space A. And number 5 is a customary condition. Would anyone wish to make a motion with regard to any recommendation on the clarified possible conditions?
move as amended / clarified. Move to
Second,
John, Linda, you seconded it?
You
did.
did.
Oh, good, thank you. Okay, any further discussion?
Rich, can you put down the share so we can see the vote?
Yeah. Okay. Comes to a vote, all in favor of recommending those clarified conditions to the full commission. If this matter is approved, they would be conditions, thus conditioned. Kindly raise your hand where Doug can see it. 1, 2, 3, 4, 5, 6, 7. And Ben is,
I'll abstain again on this one.
okay. So it's 7 in favor and 1 abstention. Let's put up the benefits and detriments staff notes. I would like to leave Mr. Hancock a little time since he's got a lot to cover. Under water quality, I think, Rich, this is going to have to be fleshed out. There should be a bullet that says the applicant is committed, has approval for 5 tie-ins from the wastewater commission and is committed to connecting all lots to the town sewer, and that the applicant is committed to complying with the MVC water quality management policy.
Agreed, that was my oversight.
That's quite all right. Stormwater, the applicant's not paving anything. We go down to energy. The applicant, Rich has included the applicant's offers with regard to complying with our energy policy and using all electric except for stovetop cooking. Under open space, I think this has to be, I think what we want to do is identify the facts. We don't need
Doug, I'm happy to have a chat with Rich to sort of clean it up a little bit.
yeah, we need the first sentence. We don't necessarily need the second sentence.
Yeah, I got it. I got you.
Okay. But we will be identifying that there is open space there. And ecology and habitat, the applicant is protecting that 1.1 acre, I believe. And then we go down to traffic and transportation. I think we should put simply that the land bank has expressed interest in seeking a trail easement, and some abutters in the Island Grove, have objected to the trail easement. Don't think we needed the applicants retracted an offer.
Understood.
Scenic values, there's a vegetative buffer. We go down to safety and health.
Well, scenic values, I think it's worth saying, here's where Division Way also has the benefit of a buffer.
Right.
We
Yes,
can add that in.
and Division Road.
I think the difference is, Meeting House Way is a public way, or at least maybe that should be clarified, and Division Road is not.
Yeah, but it ain't gonna stop people from using it, believe
Right.
me.
Well, Division Road is not a public way. The public has rights to use it.
Right,
And besides, people that live there have a right to protection as well, so
right.
Understood.
If not a right, they desire to.
a desire.
Then you go down to safety and health. I think what we want to say there is the applicant has offered to comply.
Understood.
I don't know about noise. I don't know that we know one way or the other whether the vegetative buffers would have an impact. That doesn't necessarily have any effect on the sound that would reach Island Grove. Anyone have any thoughts about that? Go ahead, Linda.
I thought about something earlier, which is the use of NA not applicable after some of these. I don't think that that is quite true. I think there are reasons why it isn't applicable and that we owe it to the public at large when we're making these decisions to say why. It's not they're unapplicable because they're on a different moon. I mean, there are reasons. You could go back to one and.
Well, yeah, we could go to coastal erosion and say not applicable because there are no.
Well, that's not the example I'm looking for. If you went back, economic impact, for example, there's some economic impact of any development that occurs on Martha's Vineyard. Now, if we want to say it's minimal, that's one thing. But to say that it's not applicable, I mean, we end up, unless this exercise is only for us and is not going to be registered someplace
Yes.
where the public might misunderstand it. I don't think that it's irrelevant whether there's an economic impact or social impact.
We don't necessarily have to even list it. We don't have to list each and every one of these every time.
Once you get out of
Well,
it.
it
There's
would be
nothing in
better.
there's nothing in the record about it. That's what, then we're just sort of making up fact. It worries me a little bit.
I think we
Well,
should.
I want to say, I want you to go back over 40 years of decisions and see how rarely we see NA. I'm just saying that you can explain an NA. And if you don't want to include it at all, don't include it. But there's something
All right, we'll take it out.
not right about NA.
I would think you've made a good point. I think if it's an NA, it doesn't belong in there at all.
Yeah,
Understood, Mr. Chairman. Those were only for note purposes for this meeting. They would never be put
Okay.
into full record.
okay, but it isn't always clear even to us whether we're deciding on something which will be registered or just for note purposes. So maybe we need to find a better format.
Well, if it's going to be in the benefits and detriments in our decision, then it is going to be recorded. Our decisions are recorded.
I'm
So,
happy to talk to Rich about it when I talk about the other stuff.
okay. By the way, ecology staff has identified ecology and habitat under environment and island housing needs under low and moderate income housing as potential primary.
What are the primary ones? Oh, ecology and habitat.
Have been identified by staff, ecology and habitat and island housing needs.
Okay,
I would think that open space would be a primary factor here since 10
yeah,
acres are being,
permanently restricted.
And it certainly preserves more open space than zoning requires.
that's right.
And again, if it weren't developed, there would be even more.
That's true. If it was owned by the town or
that-
locally.
That's a point we might make.
Okay, night lighting is straightforward. Impact on abutters. I think it should say I don't know.
I don't think it should say what's there.
I agree with that.
And I'm not sure
You
that
would
there's
just leave it
any,
alone.
I'm not sure there's any other
Take it
evidence.
out.
I have to look at the record, which we could do. Any other relevant impact on abutters? Well, it's worth looking at the record again.
Yeah, basically, they're creating 1, 2, 3, 3 lots that will abut. Actually, no. All 5 lots abut abutters, but that doesn't mean it's necessarily going to have an impact. We'll have to look at that.
You could argue it has less impact than zoning would allow.
That would be accurate.
I mean, if anything, that seems to be the major benefit of this
Hmm.
Yeah, it's
subdivision.
preserving
I
life.
agree. I agree,
It's a low density subdivision.
correct.
Island housing needs. Proposed subdivision is expected to create housing for the Ross family, one of whom is the applicant. Applicant has characterized it as a family or estate subdivision. Should any of the lots be transferred outside? Yeah. Okay. Any
It
comments
just-
on that?
It seems to be kind of a push to put that under low and moderate income housing, but
Seems that way to me. I don't think it belongs there at all. Except I guess you could say if any lot is sold outside the family, they will then comply with the affordable housing of the housing policy.
That's pretty much that last sentence, which needs
That's
to
all we
be,
need.
instead of willing to accept, but
Yeah.
will, conform.
Right.
Linda, you have your hand up?
Oh, not really. I forgot to lower it.
Okay, so island housing needs will be revised to just cover the last sentence.
Yeah.
Municipal services and taxpayers.
Hello. Yeah, I'm that's all right.
In the spirit of being a little more fulsome, I think it would say that, as we often do, that it will result, if this is true, in minimal additional municipal services, and it will add probably minimally to the tax roll.
Well, they will be using 5 sewer connections. But
Right,
that's,
so we can add that in there too. That's probably within the, yeah. Anyway, we can put a few more facts and I'll work with
Yeah.
Rich just to get the facts straight.
and public facilities repeats the wastewater system.
Yeah,
I don't know that we need necessarily the
no,
the second sentence there. And then consistent with the ability to blah, 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 blah. And,
Doug, I have my hand up.
yep, I'm sorry, go ahead, Linda.
You go back to the fire act.
Yep.
can't hear you, Linda, muted.
I'm sorry. I don't think that they have the ability to not comply with fire department regulations and recommendations. So before I would put that in there, I would go back and check, because I think they've got to anyway comply. And maybe just take the whole thing up.
Yeah, I think that really doesn't have to be there at all. And I would think that the either the planning board regulations for subdivisions or the fire department itself would have.
Right, but I don't want to imply in any way that we are giving them a choice as to whether to comply. That is between them and the town.
Yeah, okay, got it.
That's a reasonable revision. Yep.
When you talk to a fire department chief frequently, you get sensitive to this.
Yep. There's nothing in here about consistency with town, regional, and state plans or municipal development ordinances. As far as I can recall, it certainly complies with zoning bylaws. And I don't know what parts of the island plan would be applicable, so we'll have to have staff flesh that out. And the last part is appropriate, essential, in view of the alternatives. Is this development in this location is or is not essential, especially appropriate in view of the available alternatives in the island of Martha's Vineyard? Any thoughts?
Well, I think we often leave that as the sort of ultimate conclusion, and it seems to me that we frequently leave that to the commission to decide, but I don't care, and I'm gonna leave.
And I don't mind leaving it for deliberation. Linda?
Joan,
I
can I
don't
ask you
mind-
one question
I
before
don't
you?
mind, sure.
We have in our housing policy that we make allowance for family subdivisions.
Yeah. I think that
So-
that section should talk about reference family subdivisions and simply say that that the policy that's in effect at the time of a sale will apply.
Because we do sort of reference it.
Oh, definitely. Yep, I'm with you.
Okay. Linda, your hand's up.
Yes, I just wanted to say that with regard to this last statement, appropriate or essential, I think we've touched on it lightly, but it's really appropriate. I mean, it's a large lot subdivision in an area where zoning would allow a large number of small lots and all of the stresses that would go along with that on public services. So I think it's quite appropriate in view of the alternatives.
Any other comments?
I would move with what Linda said, that we recommend to the full commission that we approve this with the conditions that we have also recommended, and accepting the offers from the applicant.
As they've been clarified.
I'll
That's it,
second.
yeah.
I'll second.
Any further discussion? Okay, then it comes to a vote. There are now 7 of us to vote on it. All in favor, raise your hand where Douglas can see it. 1, 2, 3, 4, 5, 6. All opposed? Any abstention?
I'll abstain again.
Okay, so it is 7 in favor of the recommendation and 1 abstention. So what we need to do, this is on for review, I believe, deliberation and decision on the 22nd of June. So Rob, the sooner you can get them the clarified offers to us, the better. You certainly don't need to do it tomorrow, anything like that. But if you could get them in a week before, that would be helpful. So if you had
I'll get them in tomorrow once we run it by the Burke.
Okay,
Doug, you announced.
I already
the vote
did
is
them.
7-1, it's 6-1. Joan left.
6-1. Okay, excuse me. Yeah, the last one was 6-1. Okay, great. Thank you. I think we got it done. And with that, I am turning the gavel over to Mr. Hancock, who is now a specialist in stone bank building reviews, and I am recused and will leave the meeting. See everybody soon enough. Bye now. Have fun.
Okay,
And I don't know if I can participate. I'm so confused. I've
yeah,
missed.
Linda,
one or
this
two
is
of them.
just, you can participate. This is open for anybody. It's
Okay.
essentially modifications to this project.
More new modifications.
Yes, and or other issues as they come up. So
Okay.
it's basically new material.
Okay.
So Doug, Rich.
Can you hear me, Mr. Chairman?
I can.
Okay. Hold on just a sec. Okay. Got a lot of slides. I'm going to try to go through them as quickly as I can so you folks can get to the meat of talking about this. This is basically a review of compliance issues, of unapproved modifications, and of material that was specifically set aside in previous either meetings of the full commission or the LUPC, primarily the LUPC, for future deliberation and review. And the first part of, and just to be clear, this is we're talking about the Stone Bank. We're now calling the Stone Bank development. This is DRI 674 M5. There have been 4 other iterations of this DRI. And this specific set of slides will concern building D2, which is 30 Union Court, which you can actually see right here, adjacent to Tisbury's municipal parking lot, and some aspects of that particular building. And let me get underway. DRI 674 M5 Stone Bank Development. The applicant is Dunn MV Investments, also known as Dunn Family LLC. The applicant's agent is Reed Sam Dunn, goes by Sam Dunn. This is a compliance and modification review. The trigger is 1.2, modification of a previous DRI. It's a self-referral, and we're talking again about 30 Union Court, which is the 911 address that's been applied to this building, but you folks first learned about it earlier in original condominium plans as building D2. This is the area we're talking about right here on the assessor's map. And this is what the building looks like on the most recent site plan. This is the building itself. It is a 2-story dwelling, but a 3-story building. The ground floor is actually a carport, and it runs east-west. These here are planter retaining walls that appear to partially have been pre-existing, but have been expanded and repaired. There's also a fence here that does not show up very well on this particular drawing. This is Tisbury's municipal parking lot. This is real estate owned by the Steamship Authority, and this is a potential egress. This is the most recent elevation plan that we received for this property, this particular building. This wall here, this fence here has been erected. Although we have not received a fencing plan, nothing was supposed to be erected until the commission reviewed a fencing plan. Nonetheless, it was erected. The applicant has applied a wire grid on top of this fence in hopes of crawling ivy up it. These are ASIC trellises that are applied to the face of the building. Earlier plans had those trellises made of cedar. I believe earlier approved plans. These are now made of a synthetic material. This is a proposed gate in between these sort of timber retaining wall planters. These here are VTA bus shelters. The applicant is proposing fencing off behind the VTA bus shelters. And what you can't see on this plan right now is the foundation slab, which you'll see in a minute. This is just quickly a historic photo from the museum that shows a little bit of that area. Just serves to show you that there's been a beach here and the potential for water incursion for a long time. This photo is circa 1960. This is the old Steamship Authority terminal and terminal building. Close up. This is just another building that serves to show there's been a beach here for some time, and you know that the possibility for water incursion exists there. This is what the inside of the building looks like now. This is a solid slab wall, and this is the retaining wall. In this portion of the retaining wall, it's not so much a planter, it's just a retaining wall. There is a tree there, but basically a deck-like walkway has been built on it. Over here, you can see it's more of a planter. That's what it looks like now. There's some mahogany that's been laying on it. This is fresh timber woodwork here for the planter wall. You can see the east-west orientation of the parking underneath. There you can see that the planter wall is fairly solid all the way down. So this creates a wall that's not impermeable, but is fairly solid to some height between the fence and the planter wall. This is the aperture between a long contiguous retaining wall planter and a sort of satellite one here that's close to the VTA bus shelters. This is salvage granite, which the applicant has, I believe, has used some of it over as a base for the outdoor dining area in another part of the development. Another shot in between the foundation and the wall and the fence. Another shot. And this is the inside of the foundation here. One of the primary concerns of this foundation and this retaining wall and this fence in conjunction with one another is there's the possibility to inhibit stormwater flow. This is a picture of the VTA shelters. Eventually, if the applicant's plan is acted upon, fences would go behind these two shelters. It should be noted that the prior owner of this property, Sovereign Bank, entered a license agreement with the town of Tisbury, and the town of Tisbury has got permission to erect or have erected these bus shelters. So these bus shelters, according to the license that was provided to the commission, are on the applicant's real estate, and they are licensed to the town of Tisbury. This is what the fence looks like now with the wire attached to it. This is what the applicant hopes will be coated with ivy, English ivy. Close up with the wire. That planter. There's a close up of the, you can see where the old timbers are here and the new timbers were applied. There's the curb. This is sort of where the planter part of the retaining wall meets the sort of bona fide retaining wall, and there's the fence post there. This is a shot of the aperture between the two retaining wall planters. It's the hope of the Tisbury Fire Department that eventually this bollard will go away that belongs to the Steamship Authority, and this will become an emergency ingress and egress, but presently this bollard is in the way. The applicant has since sunk two posts here in hopes of generating a 10-foot wide both vehicular gate and pedestrian gate. This is the pillared side of 30 Union Court. Previous understanding of the commission was that the pillars would be here and the slab would be there, but it's the converse, and that's what's concerning about the potential for unusual stormwater flow. This creates a barrier here that may not let stormwater circulate appropriately. That's another shot. You can see the solidness here and the pillars here. There's the applicant himself underneath the building, and just to show that the wall has a little bit of a concavity in it for a closet. And lastly, or almost lastly, this is a more developed shot of the decking that is on the retaining wall. And these are some of the parking signs that are being developed. And here's a high angle view where you can see the retaining wall and the fence. And that is the long and short of that, Mr. Chairman. And I'm going to jump right into the next slideshow very quickly. So we
Rich,
get off the deliberation. Yes, sir.
Hold it.
what I'd like to do though is I think we should talk about this particular item while it's fresh in everybody's mind.
Sure
Because
enough.
I believe it is the probably one of the larger concerns here.
All right, let me round that out for you, sir. So
Can I make a suggestion too, as I watch it? I think you need to show everybody what the diversion is between what was approved and what wasn't. You went into a lot of detail. I think they understand the site. You have a drawing of what, what he was approved to do and what he's put up. I'm sorry, Fred, if you don't want me to, but
Yeah, no, that's exactly what I want to get into here, because that's
sure.
from-
you have a site plan that shows it?
Not on this slideshow, but on another
Well,
slideshow.
Well, before that goes to the commission, that needs to be put in there.
Sure thing.
Right. And I think for most people's memory, what was proposed is that this building would be all on piles, more like the Vineyard Wind building that we recently saw. So when it came with one solid wall on one side, the real question is how that affects the storm surge, and then any of the fencing in this as well, what that would do. So my feeling is that this should be the fencing for this area, and whatever mitigation or anything needs to be done because of the foundation should all be treated as one item in terms of a modification. And I further believe that I think what we need is an independent review of the stormwater surge through this building as it is built to make that determination. I don't think any of us are qualified to make that on our own. And it would seem to be, my feeling is that we should perhaps recommend to the full commission that be our course. Linda,
That's a staff recommendation as well, Mr. Chairman.
Linda, I see your hand up.
Well, frankly, it's like Fred was reading my mind. That I was just thinking, who are we to judge what the results of this might be? Intuitively, you can see that there might be a problem, but maybe there won't, and we're not structural engineers. So let's hire one.
But I think, I believe we as LUPC can't, we have to just make that recommendation to the full commission.
Fred, can I speak to this for just a moment?
Why, sure.
Well, thank you. This is not a velocity zone, and the rules are quite clear for how you build projects in, flood zones, about velocity zones and so on. And when you're in a velocity zone, you do have to be concerned about the movement of water, and there are very specific ways you handle this. This is not in a velocity zone. And, this was approved by the building inspector and the structural engineer. So, I mean, you're welcome to get a third-party view of it, because I know that's what the result will be, but I just don't want you to think this was some reckless move on our part. This foundation was designed by the late Kent Healy, and he thought this was necessary in order to resist the lateral forces, mostly of wind. And the building inspector agreed that this was not a problem in terms of storm surge, because it's not in a velocity zone.
Right. I don't think, Sam, anybody is suggesting at this point that the building was constructed improperly. The issue is really the stormwater flow through it, and it's something that our coastal planner, Liz Durkee, was also concerned about.
But okay. Well, it's fine. I'm happy to have that reviewed by somebody who's independent, but it is a building code question.
No, Sam, we're not talking, what we're talking about is how the building being constructed in this way affects the stormwater.
Yeah, what I'm saying is that, well, I don't want to argue, but I'm saying that the building code addresses how you design buildings in flood zones that are not velocity zones. So that's all I'm saying.
Yes, Linda.
I'm only saying, and I think you are too, Fred, that this came before us and we approved a plan. And technically, under Chapter 831, the building inspector and whoever else looked at this wasn't authorized to approve something that hadn't been approved by us. It should have come as the minute the building inspector or someone else in the town thought there was a problem, it should have been back before us rather than being changed and possibly causing extra expense to Sam if we decided to hold by the law and require it the way it was. So I think we want to make this all nice and tight.
Yes. So, Rich, could you give me the full screen of folks again?
You got it.
So does anybody else have any questions concerning this? And Brian, I see your little yellow hand up.
Yeah, I'm just not one to second guess Kent Healy. So I don't think any one of us on the commission have that expertise, and certainly he did. And I would favor whatever his opinion was.
Like I said, we're not at all questioning whether the building was constructed safely and appropriately. This is strictly about whether it was constructed as presented to us. And the fact that it wasn't means that we need to approve the modification. And in order to do that, we would like to find out what all the ramifications are of the project being built in this way. Ben?
Thanks, Fred. I did have a question on the height of the fence. There are view sheds to the harbor from the municipal parking lot, from Union Street. And I think the higher the fence gets, the more that view is going to be obstructed. And so I wanted to understand what the height of that fence was going to be.
The height of the fence in the portion that is alongside the building, which I don't believe restricts the view to the harbor, is for two reasons. This building is hard by the town parking lot, and it's to give some privacy to the people who are going to be walking through there and up into their unit. And it also is to the plan is for this to be a green wall, which is the trellises above will have roses going on them. The fence below will have ivy going on it. So the hope is to turn this into a green wall, which is actually an asset to the way things look there, as opposed to a detriment. And that was the intention, and I believe that could be carried out without without damaging any view to the harbor. The other problem is, and there's been a lot of talk about this recently, and I sent all this material to Rich, my new best friend, because we seem to spend a lot of time talking to each other now. There's been a terrible problem in that area with vagrancy, drugs, homeless people. It's been used as a sort of a dumping ground and a place where people hide out and do drugs, and people have been sleeping on the property, and it needs to be secured. And I've written a couple of memos to the commission about this very point, that it has to be secured. And I think that the plan we have to secure it is one that utilizes the existing foliage, and in places where we have to have openings, we're creating fences that join the foliage. So I don't think it's a radical or difficult thing I don't think it will have any impact on the views to the harbor, but I think it's very, very necessary. And the police.
Sam, how tall is the fence that's not against the building?
It's 6 feet tall.
Okay, so anybody that's not 6'4" or above, it does obstruct their view.
But the view of the parking lot, of our parking lot, you can't really see through it to the water.
No, I'm talking mostly about the fence beyond the building towards the water. That section of fence, the one that passes behind the bus shelters, all of that fence, anything higher than 4 feet is going to affect the view.
Well, I'd invite you to look at that. You may or may not have a point there. I think it's, something worth looking at because I can't picture it myself exactly as we sit here.
Yeah,
But,
I mean, that's been the problem all along, though, in this project is, things are half built or fully built, and we're talking about trying to approve those things.
Yeah,
Well,
Ben, I mean, I think what we're probably going to come into here is, I think, if my guess is that we would go as a first step to get an independent consultant about the water path, stormwater issues, to see what that comes out to, and then we would, after we get the results of that, the commission would take a vote about whether this modification with that and any suggestions the consultant has for perhaps this fence and other site issues is something we would treat as an issue and make a decision whether it needed to have a public hearing for that modification.
Yeah.
Right. The view shed issue that I'm thinking about is not, I mean, I think if you want to study the floodwater and how the floodwaters act in that way, I think Sam is partially right. It is not a velocity zone. That just means there's no wave action. If it's inundated with water, it will move around. But the view issue, it doesn't need a private consultant or an independent consultant to figure out. I mean, that's for us to determine. If we think the height of the fence needs to be lower to preserve the view, then that's something that I think the commission will be able to make, I assume.
Right. All I'm saying is that if this consultant recommends some changes that involve fences, there's no point in looking at the situation twice. We should see what the consultant recommends and then make a decision based
But
on
meanwhile, meanwhile, fences are being built.
Well,
that.
actually,
They're
they
not.
haven't. Nothing's been built in the last 2 or 3 months because Rich asked me not to. And
I would have to disagree with that, Mr. Chairman.
All right, Rich, you don't need
All
to.
right. Now, I mean, I don't think anybody is stopping you from building a temporary fence there, Sam. I mean, a temporary construction fence. I think it's at your peril that you build something that looks like a permanent fence in that location without approval.
Can I just point out that, Sam, if we find that what you're building is different than what we approve, then we have to take it back to the commission for modification. That doesn't mean they won't approve it. That doesn't mean you don't have good reasons for putting up the fence. I mean, you said there's a view shed. You said because of crime, beauty, I forget the other one. But this is the process. I just want to explain. We're just trying, where your plans diverge a little bit from what we've got, what we approved, then we have to take it back. And, these are decisions that the commission is going to have to make. As far as a peer review, we just hired a guy that we have on retainer. So I don't think it'll be too much trouble for him to get a quick look at this property and answer some of those questions, Fred.
Okay. So Linda, we haven't heard from you lately.
Yeah, I think most of what Adam just said is what I would have said. Under the processes prescribed by Chapter 831, if there is a change after our approval, we have to approve the change. It's not picking on the applicant. It's not even picking on us, although we have to do more work. We're just required to look at and approve the change. So I don't see how we can not look at this, whether we find that we need a public hearing. We may find that there's enough information already in the public record to help us make the decision, but I sure would like someone, I mean, we can all love Kent Healy as much as you want, but we need someone objective to say, yep, he was right,
Yeah, we have a
or he
person,
wasn't.
we have a person that can do that. So I'm saying that we can get that done and get it done fairly quickly and for a reasonable price.
And
Exactly.
I'm saying we should do that.
Yeah.
Well, then,
we-
fair enough. Let's do that. I just want to point out that, well, two things. One, this exact matter was discussed in January. And Fred, you wrote a memo saying what we wanted to do about it. And you know, I responded to it immediately. And, you know, then Rich came on board and, you know, this modification we're discussing right now is applied for in the first week of April. So let's do it. It's just that this project is almost finished, and you know, I'll understand that I'm doing things at risk if I do this. I totally understand that, but I can't just stand still any longer. It's been since January that this particular issue has been on your radar.
Well, then
So-
let's do it quick.
Okay, let's do it. And the other thing I want to put, this is a building code issue. And I mean, you don't need me to tell that. Hopefully the consultant will, but this is a building code issue, it's not subject to some coastal planner's notion of what may or may not happen.
That's why
You
we're going
moved
to-
the building, you moved a building and reversed it on our site plan. It may be that, but you didn't build it to what you said you were gonna build, so it's gotta be modified.
Let's,
Yes, I
let's-
totally agree.
we know what we're gonna do here.
Okay.
So let's move forward with that. The one other issue that I think needs some clarification, and I know Rich has a whole bunch of other ones, but something else that I think needs some clarification is the issue of the solar panels on the on one of the buildings. And my concern is that we might have headed down in the wrong direction on this, because our original decision said that we would prefer the building. Which one is that, Rich?
It was D1 and D2.
Yeah, it's isolated to D1 now.
Yeah, that it was, we were looking for the consultation of the Tisbury Historic Commission. We got back from the Historic Commission that they would prefer that they not be included on those buildings. And we kind of, the LUPC kind of said that because the Tisbury Historic Commission couldn't be empowered to do that, we would disregard what they had to say. And I don't think that is entirely up to LUPC to determine. So from my point of view, what I'd like to ask Sam is this something do you want to pursue the solar panels on those buildings?
Well, again, following the meeting in
I
January
understand.
and the memo from you, you said make a proposal. And I did that very quickly, and it showed solar panels on building D1. And it's prepared, and I've submitted, you know, the plans of the solar to Rich and all the solar calculations and all of that stuff. And I'm prepared to do it in the interest of harmony. I think, you know, we could argue about this point, but I'm saying, I think that's a reasonable compromise, and I'm prepared to do it. But
Okay, I'm not, Sam, I'm just trying to get this straightened away and be consistent with our decision. And I think the only way to do that would be to bring it back to the full commission, because I don't think that LUPC can say, oh, we don't agree with the historic commission and we want you to do it anyway. That's
Yeah,
kind of my feeling about this.
Right, Fred, but I think
since
all
I've
of these
agreed to do
things-
it,
all of these things are gonna have to go back to the full commission.
I know, but the original condition said that it would be determined by
Oh, by
LUPC.
LUPC, I got you. So you're saying that because it's so different that you don't feel comfortable with LUPC to do it, that it has to go to the full. Well, couldn't we put
Well,
it together then in the package of the amendments that we're gonna make?
Yeah, because the Tisbury Historic Commission said that they didn't think it was appropriate, that should be the end of LUPC's approval process for that.
Mhm.
And if it's something that, I'm not sure how it goes back to the full commission at this point. Because it
Sam
looks
made an
like
offer.
in light of our decision that it should be a dead issue.
All right, if you feel that way, I guess that's what we take it back and say,
I don't know, does anybody else feel that way?
I didn't understand what you were saying, so
he's saying
Um,
that because the historic district, our condition basically was go to the historic district and then come back to LUPC. It did that, and the historic commission said, you don't really need to do it,
We'd rather not have them.
rather not
Yeah,
have them.
Fred, I think one concern at the time was that the LUPC stated that the historical commission wouldn't have that authority on its own.
it doesn't.
It-
And we
it
can't
doesn't.
give it to them.
We can't give it to them, but we should also, if we're asking for their opinion, we shouldn't just ignore it and say we know better.
Yeah, but I don't want to just hear they said X. I want to know why. I mean, where is it visible
They-
from? All of those things.
They wrote a letter to us
I
about
wrote a
it.
report.
Does that tell us where you can see the panels from?
no. to
No,
be-
it
to
said
be
they didn't
absolutely-
think,
Sorry for interrupting, but the condition states quite clearly that you wanted solar panels on these two roofs,
Yep.
assuming if approved by the historic commission. Now,
Can't
I
give them that
understand the
authority.
conundrum. You can't do it, but you did do it. So in order to compromise this and make it all go away, I offered to put them on one of the buildings, and I've had it designed and it's been before you for a long time. So I thought that was a very reasonable offer on my part.
And where are they on it?
that's what we're trying to determine here, Linda. And I think what we need to do is send it back to the full commission as a modification.
In other words, so we asked the full commission to approve just on one building. And having done that, we asked the Tisbury Historic Commission, how do you feel about this?
No, I think that the historic commission is out of the game at this
We're
point.
done.
It's just up to the commission to make that determination.
Okay, I guess my problem is that the input that we got from them doesn't help me understand the situation. The question, I'd love to be able to ask them some specific questions.
Well, we'll have the report available
Okay,
from when we come back to the
yeah,
commission.
I mean, my concern comes right back to the fact, can you see these from any major?
Right, we're going to get,
public view?
we'll deal with that when it comes to
Okay.
the commission. Brian,
Yeah, just for clarification, Fred, so there's been several issues that have been sent back to LUPC for determination, correct? And it sounds like LUPC is not in a position to recommend or vote on that without the full commission being involved or their approval. right?
Two slightly different things. On the first one involving the foundation and the water flow through it,
Right,
the applicant is asked for a modification because what was built was not what was
right.
sent to us to begin with. So that is a recommendation to the commission that we hire a consultant to give us information about that. This is something that was supposed to be an LUP. The solar panel part was something that was supposed to be an LUPC decision with the input of the historic commission.
All right, so how do we bundle these together and move forward?
Well, I think they need to be two separate deals, but I think this one can go forward much more quickly than the other
Which
because
one?
we don't need an independent consultant for this.
Solar panel.
For the solar panels?
Yeah. Yeah, the solar panel issue. Ben,
Thanks, Fred. Let's remember that the reason the Historic Commission was involved was that one of the buildings, the Stone Bank building, was the historic building. The solar panels on any of the other buildings really isn't a Historic Commission issue. It's not in a historic district. So I think we're sort of overworking that piece of it. The solution that Sam has presented is really the only viable solution left, given that everything's been built. I think we should keep that in mind. I think what was the concern was really enough of an effort to meet sort of the goals that people have for how much solar we should be generating. That's really the heart of the question. Is Sam putting it in the right location? Yeah, he set up a south-facing dormer where he can put, I think it was 280 square feet of solar. If we feel that's enough, that's a simple one. We can deal with that one pretty simply.
yeah, so that is something that I think I don't think we have the plans today to look at it, but I wanted to make sure that we had the procedure in place and everybody was happy with it, that's going to go to the full commission as a modification of the existing condition on solar panels.
Mr. Chairman, we do have those plans, and also I can also show you the originally approved elevation for building D2, if you'd like.
Why, sure.
You could also put up the condition, which is,
Yeah.
quite explicit.
No, this is the southern facing elevation here. Can everyone see that?
Yeah.
That's the southern facing elevation there. So the fence.
I would point out that it's quite vague in terms of, it's a preliminary drawing. It's very vague about trellises and planting. You can see that there's planting shown sort of all over the facade. That led me to understand that, I had some latitude in how this would go. So
are we back on the previous issue?
I don't know.
Rich, I don't think these are the plans that the commission.
So why don't we not do the
Yeah.
we'll take 2
Let's-
hours to do the solar. This is
Let's figure that we can do the solar situation and that
Okay.
could I think that's in shape to go to the commission.
Yep. What's the
And
next?
we'll do the others as we get to them. Ben, did you have something else, or is your hand left up?
My hand's left up. Hold on, I'll pull it down.
Okay. All right. So this is the elevation at Rich. Can you show them which roofs we're talking about here?
Yep, I will. This has both of the buildings that we were just talking about side by side. So this building here, this is D2, 30 Union Court. This is the one with the question about whether or not stormwater would be affected by any of the modifications. This building here, D2, this is where the proposed solar panels would go. Unlike any other roof in this complex, this has an asphalt roof, ostensibly because it might have been overkill to put cedar underneath solar panels.
And it's one unobstructed surface, so it's been prepared for this.
Okay,
All right.
yeah.
Yeah,
So here we go. So this is the beginning of the other type of fencing that was erected on the property. This is wire fencing with a wooden frame, and this is cutting across the, this is essentially the dividing line between the so-called public pocket park and the set-aside area for some of these buildings. This is the most recent site plan that was given by the applicant. And this is a close-up of the area where the wooden wire fencing is going right along here. Public travels down here towards the pocket park. Down here is eventually the taqueria. This area is offices. There's a sound studio proposed to go in here, and offices along here, and on the upper stories there are residences. There's a gate that has been installed here.
so
Again-
just so everybody knows, this is another fence, and I think we should treat it differently from the one that's down by the water, because it is a totally separate area. But again, it's something that was not on our original plans.
Yeah,
And I think it's important because this whole area, I believe, was presented to us as a public amenity of open space.
This is the gate which divides the pocket park to another area. The applicant has indicated that he fact in one of the decisions that he has reused some brick from other parts of the project, salvaged it to make these pathways. This is a gate that leads towards the municipal parking lot underneath an arbor. This is building D1 where the solar panels would go. Another view of the fencing, lower view of the fencing here. This is going against the stone bank proper. That's the historic building. Another view of the gate and some other fencing that we'll talk about in a minute. This is a high angle view. You can see almost the whole breadth of this type of fencing. The applicant has stated that shrubbery will be planted on either side. There are some Japanese cypress that have already been planted. And I believe it was a condition of one decision that some of these buildings be screened in some manner. I'm not specifically aware. This is just included because the applicant has applied for wastewater flow for 75 Main Street, which is the top.
Yeah, let's not get into that, Rich, at the moment, because we don't
That's
have
only-
anything.
Sure, that's only being included to indicate that there could be greater volume moving through this area. That's all. Nothing else about that.
If
I'm almost done on this section, sir. In the originally approved building plans, this is a section of fence, an architectural element that was on a drawing set that shows essentially what's on the ground now, but not where it would go.
Okay, and so Sam, did you have something you wanted to add?
Yeah, I'm having trouble. Can you hear me?
Yep.
Okay, so that fence is on the original plans, the one that's the wire fence. And, there's been really no change to that from day one. That was isolating the public from the private part of the project. And the part on the far side of the fence that you see there is a is a private courtyard for the, tenants and residents of that part of the project. Everything else is public. And, the idea is it's a wire fence, so it's not too off-putting, and it's going to be grown up on both sides with shrubbery and trees. So it should be, it's what's been on the plan since day one. Also, both gates were on the
So you-
plan.
you're-
Okay, I think
you're-
we can go back and look at plans that we approved to determine that.
Yeah.
Right.
I don't recall seeing it, but Ben, did you have a question? Comment?
Yeah, thanks, Fred. Sam has always indicated that he wanted to have this division between what is the primary public space and what is sort of a secondary space that is more private for the residents. And this has always been an issue because the first floors of those buildings are supposed to be commercial. And, if you're going to those businesses, whatever is located on the first floor, you're passing through this private space. And so my question, Sam, is how are you going to deal with, there going to be signage that says, come through there to visit those commercial businesses that will be on the first floor?
Yeah, well, those commercial businesses.
And the other piece before, and before that, the other thing is it's also just the height of the fence. This area just keeps getting constricted and constricted when and we're losing that open feeling of it. And I think the expectation was that the fence wouldn't be as tall as it's built now.
Well, this fence that you see there has a level top. At one end, it's only about 3 feet tall at the top end, and it's about six feet tall at the other end. And I do believe that.
Yeah, no, I follow that.
Yeah, and the fence you see on the left is actually, the fence on the left is the solid wood fence is actually on the property of the green room building. That's to isolate
Yeah,
their
no, we're not
trash.
talking about that fence, though.
Okay. So this is, this pocket
But
park.
the question I had was how do the commercial first floor
Okay.
businesses within that private fenced in area, how do they operate? How
No,
do people get to them?
Well, the sound studio is operating now, and the people come through there. It's not. They have. These are not like retail stores. They're going to be offices and the sound studio. The only space is the commercial space.
So, so my question was the signage, right? How do you envision the signage working to allow people to know you're allowed to pass through what is going to feel like a private space if you're visiting one of those commercial spaces?
Well, initially I'd hope not to have any signage, but I have signs made that we will use if we need to. They say something very friendly like residents and tenants only, please. That would be on these gates at both ends.
So I guess
What
the
about the
question is,
commercial businesses?
Are
Well,
they
they're
locked, Sam, or are they?
No, they're not locked. And people are used to wandering through there, but it's starting to work the way it's supposed to. If I could finish this pocket park, I think it would work really great. That people from the ferry, there's a totally smooth way to go through the pocket park and up to Main Street. It's really, I think it's all worked out. It just needs to get done, and I think it's going to work really smoothly and accomplish everything it's supposed to accomplish.
So basically this is a question of whether this is on the original plan or not, and if it's not,
Yeah.
you have to make a decision about it.
It is on.
I'm just trying to move us through this.
Right.
Well, I
that's
think
the issue, Adam.
also these things at the original decision time were incorporated into what would be a final landscaping plan. And so the details, where the plants are going, the height of the fence, the layout, the gates, all of that was going to be contemplated in the final landscaping plan, which we haven't reviewed.
Well, he can make that argument.
If
That's your position. He can make that argument, and the commission will decide what
Well, the landscape plan was submitted over 2 months ago.
Well, we're not talking about the landscaping plan and Sam, if you want to get into what you submit and what we accept, I'm glad to sit here forever. I'm trying to get you through it and you keep acting like somehow you're an innocent victim here. We need to just
I
look at.
certainly don't feel like a victim.
Let me finish. We need to look at whether the fence is on the plan and whether the commission, even if it's not, whether the commission thinks it's okay, or in Ben's case, that it needs to be considered as part of a larger example. Did I hit all those right, Ben? I think I did.
Well,
There's
no, I
three.
mean, what it basically, a lot of this stuff falls usually onto a landscaping plan. Sort of the placement of the trees that have already been planted, the size and the type of the fence, and the location of the gates. All that sort of stuff. When we originally approved it, we had contemplated doing that within the confines of reviewing the landscaping plan. But with this project, we're reviewing things that are both not yet on a plan but built, and that's frustrated and really confounded this process. And so we're stuck trying to think about what did we think 2 years ago or a year ago or whenever it was that we were contemplating these things. Yet the building continues, and so at some point we have to get to a final realization of like, okay, what exactly is going to be built? You put us in the awkward position of, if we don't like what's already been built, are we going to just approve it because it's kind of already done, or are we going to force you to have to remove things, modify things? That's frustrating. That's a frustrating thing to have to deal with.
Well, if you want to talk about,
and all along, I've had issues with sort of the private takeover of what should be commercial space. This is the B1 district. It's not the R10, which it abuts. If you wanted to develop private residential yards, that's stuff that's done in a residential district, not in a commercial district. And those first floor units are supposed to be commercial. And so, they're more and more every day appearing to be private residences. And I really question whether they're even commercial. I mean, I know that sound studio is there, but I wonder what's going to happen to those other spaces.
well, if you would like to come over and see what's happened, there's my son and my office is, and our office is in one of the units. The condominium office is in another one, and another one's for rent. I mean, I just, I think you're leaping to a conclusion there that isn't really fair. But to your other point, what you talk about frustration. I submitted a landscape plan over 2 months ago, and it's never been heard by either the planning board or the LUPC. And planning season is now. Everybody knows it. And the project's, getting finished. Am I supposed to just do nothing and leave this place as bare dirt until the boards get around to looking at it? I mean, that's not fair or reasonable.
All right,
Mr. Chairman,
Rich, just.
Yeah.
Oh, yeah, no, I'm just
Yes.
saying there's more to go, and there is actually a landscape plan to vote on in this presentation.
I'm not sure if we're going to have time to take a look at this tonight. I think I haven't had a chance to look at the landscaping plan, and I don't know if any of the other members have. I think it would be a little premature to jump into that tonight.
Sure, well, it's available for review then, sir, if you would like.
Yeah.
I think Brian's hand is up, Fred.
Yeah, Brian?
Yeah, I'm just looking for a path to move forward. I mean, if the applicant, did landscaping without coming to us prior, he did it at his peril. But we need to now review what his landscaping plan was, what has been done, and what are the steps that we need to take to get this off our plate.
Yes, no, I totally agree. I mean, that's my plan in all of this is to try and get everything looked at that needs to be looked at, so that hopefully by the time the construction is done, he's not held up further waiting for other approvals to get his certificate of compliance from us. So, Linda?
Yeah, well, first of all, I gotta say, if the plan has been, quote, before the commission for many months, it's unfortunate that we haven't started reviewing it. Tonight's meeting was most specifically not posted as approval of a landscaping plan. We need to do that. And it is true that when we review landscaping plans, we review things like location of fences, but we're not usually doing it after the fact when they've been already installed. And I just want to say something. I think that what Ben was talking about earlier, and Sam said he was making assumptions that are not, I don't know, conclusive. I don't know, that the evidence isn't conclusive. I think Ben was suggesting, it's like the Robert Frost poem. Good fences make good neighbors. When you see a fence, you think there's a boundary. You don't feel fully comfortable crossing that fence unless there is a gate that's wide open or with signage that says, welcome, come on into such and such a business. There is a psychological issue about these fences that I think is very real to the way the project functions in the economy and with regard to the neighbors. So I think we need to deal with it, but we're sort of flailing away at this, not knowing what is the specific topic that is before us. Please.
Well, could I suggest a site visit? I think, that would be very helpful.
Right. I think what we need to do is look at this proposed landscaping, the landscaping plan, and it doesn't have to be at a meeting, but have it available for members to look at, and then yes, do a site visit.
Yeah.
Because I went by this afternoon just to take a look at things, because obviously it's very different in person than seeing it on the plan. So
Yeah.
if we can make those arrangements, it would be a good thing.
But I just want to weigh in advance with what I think is support of Ben's position. The fences imply privacy. So if you put a fence between an openly public area and a slightly more private, the offices are over here type area, a lot of people are going to feel excluded by that
Right.
fence.
And that's something that we can deal with when we're looking at the landscaping plan and after having
Yes.
taken a site
Yes.
visit.
Yes,
Right.
but and usually I don't go to site visits, but this is complex.
Yeah.
We really need to see it to understand it.
And Fred,
Absolutely.
as far as I can tell, the fence around the courtyard was not presented originally and was not discussed as part of the original DRI. So that we can go back to the record and find that, but that's the best I can tell from that.
Right. That was certainly my recollection of it. So anyway, I think we're talking
Can I
about
just
it
make
being.
one more? I'm sorry, Fred, go ahead.
Yeah, I think we're talking about looking at it now anyway, in conjunction with the landscaping plan. But yes, it would be helpful to look at the plans that we approved to see if that line is on there.
I just want to say, first of all, Sam, is talented. He's done good projects, but it is true that everything that comes into us is not quite what we approve. We have to go through the process. And most of the time it's not stamped and it's not exact. And we're just trying to get through the process. And the building official has the same problem. Last week, we allowed several things to open. Normally we don't do that, but we did out of respect for Sam and out of respect for the process. We just have to get through the process. And if you want to do that and put it on every agenda for LUPC and the stuff.
But
I
can we
believe that
post,
could. But
can we post a site visit in such a manner that we can, keep within the bounds of the open meeting law, and also invite the Tisbury building inspector to be part of that process? We want to see the same things. We want to be able to discuss them. What?
we've had it. We've had that with, and we can couch it in terms of compliance. I still don't know that we can have an open meeting. Fred, you might know. I still don't think we can have, we might have to do a site visit in two groups, to keep under the people, because I don't know that the public hearing is closed. So I don't think we can.
Right. I mean, we can, if we have just a site visit, there's no quorum issue because we're not, we're not meeting as LUPC.
Okay, well, we can set that up, Sam. We can set that up with
Yeah,
you.
and-
with the building official.
I'd really be pleased to do that, and I think it would be very useful. And, with
Sam will
respect to
call
building
it a
inspector,
party. Call
don't
it a
have a
party,
building-
invite us to the party, Sam.
we don't have a building inspector now either. It's kind of another issue.
Oh,
That's-
well, let's have a
Right.
party without him then.
And I just wanted to say, not that I'm the most important person in the world, but I'm leaving next Tuesday through the end of the month. So
And I'm in a wheelchair, but hey,
but there are nice ramps there.
good, that's good. Well, I don't own a wheelchair. I've been pushing a,
Mr. Chairman, there's a little bit more presentation to get through.
Yeah, I think we're gonna bag it for now, my friend. Because
Fred,
we're, I
can
think,
can I just ask a question, Fred?
Yeah.
Just a procedural question. So if we do a site review, this is a site review to gain knowledge, to come back to LUPC for the landscaping plan? Is that the purpose of the site review?
I believe so.
that would keep us clean.
Okay, and then after that site review, we'd have another discussion, and then we would present this to the full commission if we so decided?
I don't know. I mean, again, it depends on, I think, on whether the plan is, the fence, this fence we're talking about is on the plan that we approved. And B, whether, I think the original decision, as it usually does, says that the landscape plan is approved by LUPC. If
Okay, so the
We
applicant only
might-
needs, the applicant is only looking for LUPC approval. That's what.
Yep, but
decision has
that's not
said.
the only issue. We do have the
Right.
problem of non-compliance with the original decision.
Right, so
Mhm.
that's the issue, and
Other issue.
depending on, we could possibly approve the landscaping plan. And we would have to make a decision about whether the fence was included in that landscaping plan. Or if we felt that was an issue that needed to go back to the full commission.
Yeah, I think so, but it's not just a fence. Remember that under that building, a wall has been altered.
That's a separate issue, Linda. I think,
So it's a
no, I mean,
third
because
issue.
if we try and roll too many things into one package, we're doomed.
Right, so Fred, again, upon compliance, we don't have a compliance officer. We used to have a compliance committee, which I'm not sure still exists. So wouldn't compliance go back to the building inspector, who would have to refer the non-compliance to us?
Yes,
Here's the issue, Brian. We have in our procedure, the executive director and DRI coordinator have to issue a certificate of compliance for the building inspector to issue the certificate of occupancy.
Well, actually, that's not one of your conditions, but
Want to try it without it?
Well, I mean-
Of course it is. We do it with everybody else but you. So what are you talking about? We CO everything.
But
I'm just, look, the building inspector said it's not a condition, and so he can't,
Yeah, well, the building
what he-
official told me that it was certainly a condition.
well, okay,
So
look,
if you want to go there, Sam,
I've
I'll be
got-
glad to stand there with you.
I don't want to go anywhere
Nor
except
do I,
forward.
nor do I.
Forward. And I
So
have
let's-
a very large, complicated project that's not all finished at the same time, and we need rolling occupancies. So, a hard and fast rule about getting a, certificate of completion on the entire project, it doesn't really work in this case, and that's why we came to you. And I think it was everybody.
we understand that, Sam, and that's, one of the things that we're talking about, that won't help you, but in the future for a campus type plan, we need to be able to do that kind of, as you said, a rolling occupancy.
Yeah.
What is conditional on the total plan, the total development being built, and what can be approved with each building. And that's certainly one of the things that we didn't think through as well as we should have with this project.
So
So do
here
you
we
need
are. Yeah.
Do you need a motion, Fred?
No, I think I think we're just ready I think where we are is the result of this is we're hiring a peer review for the stormwater issue to determine how we proceed in that area, so that can come back to the full commission with the input from a peer review to decide on that modification to the foundation. And then we will decide at that point whether that and or the fence that is part of that in that area need to have a public hearing, or if it can just be said that it's a minor modification.
I respectfully think we've got one modification and one approval of a landscaping plan, and those are
Right.
really
Linda,
separate
let me finish.
things.
I'm trying to lay out the total project here. Okay, we're talking about in the building down by the water, the peer review for that, just to determine that's one major issue, the not built as it was presented to us. Then we're moving inside, and also that other fencing plan down there, which may or may not be part of the same peer review issues. So we're waiting for the report on that. Then moving to the south a little bit, up to this next building that we were just talking about, with the fence and landscaping issues of that. Again, that's an issue where we're going to go back to the record and see if the fence that we're talking about was on the initial plan, and decide if it's part of the landscaping plan, whether we feel as LUPC we can approve that fence there as part of the landscaping plan, or if the fence needs to go back to the full commission for approval as a modification.
Mr. Chairman, there are other modifications I have not yet articulated.
I know, but the hour is getting late, and I think we've kind of reached our limit of things that we can deal with tonight.
Yeah, we'll put it
Ben,
on.
is your hand still up, or is it just left over?
Yeah, leftover,
Yeah,
sorry.
I mistakenly didn't take it down.
We'll put Sam on the next agenda and go over Rich's remainder.
Yeah, I just don't think that we have the rest of the
We'll do the
bandwidth.
site visit. For when the site visit, Rich will include your other ones that you didn't get to on the site visit, so everybody can see all of the potential stuff.
Right. And I think one of the I having looked at all the issues that we're talking about, the ones that we spent the major amount of time talking about today are the more major issues involved here, I think. So that's where we are. Okay,
Right. Good night.
I put my hand back up.
yes,
I do want to say something. I think that we need staff and possibly Fred or one or two other commissioners to get together with Sam and help him to develop what he needs to present to us. I mean, not the content, but the subject matter. Dear Sam, we need details here, we need details there.
yes,
And
we will take
whatever.
care of
I
all of
think
that.
this is too big a group to be doing that kind of work.
Yep. All right. Thank you, everyone.
Thank you, Fred.
Fred, that was fun.
Let me
Always.
know when the site visit is.
Oh,
Yeah, Rich will get with you with that.
Okay. All right, guys. Thank you.
bye, Sam.
Bye.
Bye, Carol. No, are you leaving?